5 seconds to go. Start. The benevolent clause extending the benefit of compassionate appointment even beyond reasonable limits, obviously to cover exceptional cases for ensuring the right of the family members of the deceased employee to live with human dignity. The idea for incorporation of this clause in the scheme of 1993 cannot be confused with grant release of terminal benefits. Both operate in different arena and therefore we respectfully disagree with the reasoning in paragraph 19 of Canara Bank Supra as pertinently held in B. Kishore Supra, indigence of the dependents of the deceased employee is the fundamental condition to be satisfied under any scheme for appointment on compassionate ground, and that if such indigence is not proved, grant of relief in furtherance of protective discrimination would result in a sort of reservation for the dependents of the employee dying in harness, thereby directly conflicting with the ideal of equality guaranteed under Articles 14 and 16 of the Constitution. Also, judicial decisions abound that in deciding a claim for appointment on compassionate grounds, the financial situation of the deceased employee's family must be assessed. In a situation otherwise, the purpose of the scheme may be undermined. Without this evaluation, any dependent of an employee who dies while in service might claim a right to employment as if it is heritable. The ratio decidendi of all these decisions have to be read in harmony to achieve the noble goal of giving succor to the dependents of the employee dying in harness who are genuinely in need, and not with the aim of giving them a post for another post. One has to remember in this connection the caution sounded in Umesh Kumar Nagpal Supra that as against the destitute family of the deceased, there are millions of other families which are equally, if not more, destitute. Premised on the aforesaid reasoning of ours, we conclude that the order of the MD and CEO refusing to grant the prayer of the respondent for compassionate appointment was unexceptionable and therefore not liable to any interference in the exercise of writ jurisdiction. At the same time, we cannot be oblivious of Canara Bank Supra having been rendered by a coordinate bench. Having disagreed with Canara Bank Supra, judicial propriety demands that we follow the appropriate course, that is, to refer the matter to a larger bench. We are also not oblivious of the legal position that so long the decision that is doubted is overruled, it continues to remain binding. A reference to a larger bench as made by the coordinate bench in Shio Shankar Tewari Supra, if made by us, would only add to the agony and pain of the respondent, considering that one cannot foresee an imminent resolution of the controversy in light of the admitted fact that the reference made by Shio Shankar Tewari Supra in 2019 is still unanswered. Having regard to the foregoing discussion of the predicament faced by the High Court, we cannot hold the impugned order to be entirely unjustified. To the extent it has relied on Canara Bank Supra, we cannot fault the division bench or, for that matter, the single bench. The division bench, feeling bound by Canara Bank Supra, did not have the occasion to enter into a proper examination of the order of the MD and CEO. It was of the clear impression that the said order was in the teeth of what was held in paragraph 19 by this court in Canara Bank Supra. However, at the same time, we are of the firm opinion that notwithstanding Canara Bank Supra, The division bench ought not to have overlooked the criterion relating to suitability while directing appointment of the respondent straight away. To this extent, learned counsel for the appellant is right that the question of suitability was left untouched by Canara Bank Supra, and the appellant ought not to have been made to suffer an order on its appeal having more adverse consequences than the order on the writ petition. In the fitness of things, we have decided to invoke our powers under Article 142 of the Constitution. Another coordinate bench seized of this appeal appears to have observed on 21st May 2024 that it would consider making a direction for payment of a lump sum amount to the respondent towards full and final settlement, and accordingly time was granted to the parties to obtain instructions. Though no agreement was reached and whether the respondent is covered under the scheme of 2005 for lump sum ex gratia payment has not been examined by us as well as by the High Court, but bearing in mind the approach of the coordinate bench coupled with the circumstance of hope being generated in the mind of the respondent for appointment based on his success before the High Court, we are satisfied that interest of justice would be sufficiently served if the appellant is directed to make a lump sum payment of rupees 2.5 lakh to the respondent within a period of 2 months from date and the proceedings be closed. It is ordered accordingly. We hasten to add that this would be in addition to rupees 50,000 paid to the respondent in terms of an earlier order of another coordinate bench while issuing notice. In the final analysis, the impugned judgment and order of the division bench as well as that of the single bench stands set aside. The civil appeal is allowed on the aforesaid terms. No cause.